All right. Welcome, everyone, to New York Arbitration Week 2021. I'm Steve Skulnick. I'm here wearing my hat as the Program Committee Chair for the Chartered Institute of Arbitrators, New York branch. The branch, along with the New York International Arbitration Center, known as NIAC, are pleased to present this third Arbitration Week. Before we get started, I would like to ask you all, if you have questions for today's panel, to put them in the Q&A. The chat is also open, but the Q&A is where your question will be noticed. Before turning over the mic, I do need to acknowledge and thank our financial sponsors. There are too many to name, but they're up on the screen for you, and you can also see all of the materials, including these organizations, at nyarbitrationweek.com. As I said, the Chartered Institute New York branch and NIAC appoint the organizing committee, who I'd like to thank. This year, they are chaired by Matthew Draper and Lee Haber-Cook, and joined by Xian Bao, Steph Cohen, Mike Fernandez, Katie Gonzalez, Benno Kimmelman, Dana McGrath, Rekha Rangachari, Jeff Rosenthal, Daniel Schimmel, Eduardo Zaletta, and our secretaries, Alex Hayden and Jesse Peters. And I'd like to get right to our program. The theme this week is on getting it right in arbitration. And I'm pleased to introduce Eric Tuckman, Senior Vice President and General Counsel of the AAA ICDR, who is going to kick us off in our first program. Eric?
Thank you very much, Steve, and Rekha as well. And good day, everybody, and welcome to New York Arbitration Week. The AAA ICDR's program today, Getting It Right, and in-house counsel's discussion on their approaches to international oil and gas arbitrations, is really leading off an excellent week of programming. And of course, our thanks go to NIAC, the New York International Arbitration Center, and the New York branch of the Chartered Institute of Arbitrators for doing such a great job. Also, Steve had just indicated the members of the organizing committee, chaired by Matthew Draper and Leah Haber-Cook, along with a cast of thousands. It's a major effort to put on a program like this, and they've really just done a great job, as they do every year. So our session is going to continue somewhat the ICDR's tradition for New York Arbitration Week of taking the opportunity to pull together in-house counsel so they can share their perspectives, really critical perspectives on developments in international arbitration. And this year, our focus is on energy, the energy industry, getting it right in in-house counsel's discussion on their approaches to international oil and gas. And we're really fortunate to have an outstanding representation of highly experienced attorneys who just have significant depth in managing different types of disputes over a period of time. So they can also share valued perspective with respect to what their organizations are facing with regard to the pandemic, with regard to a lot of the natural disasters that are impacting their fields. And so we're really fortunate to have them. I want to emphasize that, of course, the views that they're expressing and the issues they're discussing are their own individual views and not really necessarily the views of the companies that they represent. And with that, I'll just briefly indicate who our speakers are, but then I'm going to ask each of them just to spend just a minute describing their areas of responsibility, because it's from those perspectives that they'll be speaking. And I think it's important that everybody here understand what that background is. So we have Susanna Blades from ConocoPhillips, Edward Diggs from Bechtel, Theresa Garcia-Reyes from Baker Hughes, Kevin Feeney from Shell, and Eugene Silva from ExxonMobil. Susanna, do you want to start us off and just spend a moment
Sure. Good morning.
What you do from day to day?
Sure. Thank you, Eric. Good morning, everyone. Thank you for inviting me to be on this amazing panel. Yeah, so I manage global commercial litigation arbitration disputes here at ConocoPhillips out of Houston, Texas. And so my team is responsible for, like I said, commercial issues, international litigation, domestic arbitration, international arbitration, investment dispute arbitration. So covers a wide range of different matters globally. So that's basically what we do.
Thank you. Edward Diggs.
Yes, thanks, Eric. And please, Ed, call me Ed. Yeah, I manage all of the construction claims for Bechtel Energy, the business unit for Bechtel Corporation. And I manage those worldwide, both on the domestic and international front.
Great. Theresa.
Hi, everybody. My name is Theresa Garcia-Reyes. I'm with Baker Hughes, which is an energy transition company in the space. My team is responsible for managing all litigations and arbitrations worldwide, both in the domestic courts around the world, as well as anything ADR related. So anything that goes to mediation, arbitration, and that's it.
Play. Kevin.
Thanks, Eric. Good morning, and thanks for having me. As Eric mentioned, I'm with Shell. I'm based in Houston. My area of responsibility is primarily the US and the Americas, but largely US focused, although I do have some disputes in Europe and the Middle East. And that is arbitration, mediation, litigation, in whatever form the disputes materialize. And my focus is on upstream, integrated gas, and LNG complex commercial disputes.
Great, thank you. And Eugene.
Yeah, my name is Gene Silva. I'm a member of the company's International Disputes Group, where we handle all non-US litigation and arbitration.
Okay, so speakers, a lot of arbitration expertise, but also both internationally, domestically, some investment, and importantly, domestic and international matters. So there has been really significant disruption in the energy field over the past year and a half, perhaps a little more, resulting from the pandemic, from COVID. We've seen oil prices, for example, hit rock bottom just a little more than a year ago, and they've recovered, expected to go back up, with those inflationary concerns and the like. And so, given that environment, given all that disruption, there's different ways of thinking about it and different experiences among companies. Some find that it's a time to hunker down. It's not going to be a time to really invest in disputes that might be arising because there's so much uncertainty. Others take the view that you've got to strike while the iron's hot, and you need to be aggressive and assertive and protect your positions. So if we could just hear a little bit about your views about what the past year and a half has been like for your organizations and what you think has driven some of the outcomes you're facing. Have you seen a larger or smaller number of arbitrations being filed or that you're defending against in the last year or two? And do you think, would you agree with the statement that either you or your business partners might be a little more reluctant to file a asserted claim in its current time? Susanna, we'll start with you, if that's okay.
Sure. Yeah, we, in the beginning of the pandemic, we saw a huge number of force majeure notices being exchanged. And while no claims were being filed back then, we were expecting that a big wave of new lawsuits and arbitrations would come, but I should say we haven't seen that. I think the parties are now excited that the pandemic is largely behind us and oil and gas prices are high. So everybody wants to get back to business, and so in the E&P side, and I'll be interested to see what Jean and Kevin say, but we haven't seen a lot of claims. I mean, there are a few, obviously, but not the wave of new lawsuits and arbitrations that we were expecting. I think largely everybody wants to try to get those disputes resolved amicably and get back to business.
Mm-hmm. Mm-hmm. Ed, you've got a slightly different view, I think, perspective, perhaps, given the difference in Bechtel's involvement in energy.
Well, yeah, on the construction side, like Suzanne, we haven't really seen an uptick on claims. We've seen a lot of notices, but the jury is kind of still out on claims for the most part. That's arising out of the pandemic. We're seeing more impacts coming out of the supply chain. And so if your construction project is kind of beyond the procurement phase, you're probably unlikely to see significant impacts. If you're in the throes of the procurement phase, then you're going to see quite a bit of interference and disruption, and you'll see some claims trickling in. But because of the uncertainty that's still out there in the pandemic, right? You're still required to and subject to different restrictions in different parts of the country, so it varies, and that can have a long-lasting effect. So you don't see the claims being pressed yet because they can't really quantify those claims just yet. So we're not out of the woods yet. The wave is still there. My experience over the years that in the softer markets and in the lean years, we typically see it being a little more challenging to resolve claims through settlement purposes, for settlement reasons. We typically see those claims advance further in the dispute process. People are just trying to hang on to more dollars, and particularly if there's not, future work that's forecasted, then it makes it a little more challenging for the parties to reach settlement agreements. So we see the litigation actually pick up in the leaner years more so than we see in the more robust years.
Okay, interesting. Jean?
I largely echo what Susanna said. I think we were certainly expecting an uptick with COVID, especially I think as we all thought there would be a lot of force majeure type work. And that never really materialized. I think we all learned an important lesson that force majeure is something that happens when there's a disruption that affects a few people. But if everyone's world goes sideways at the same time in the same way, there's almost in certain commercial relationships no point in declaring force majeure because there's not another deal you can do. You're kind of stuck with everyone's kind of stuck in the same spot. So I certainly haven't seen an appreciable change in the flow of work, but your mileage may vary.
Mm-hmm. Okay, Kevin.
My experience is probably a little more anecdotal because I'm not managing a team. I'm looking at my own docket, but from my understanding of my conversations with my colleagues, and it's been very consistent with what Susanna and Jean said in terms of there certainly was a lot of preparation and a lot of work in preparation for this wave of force majeure related disputes that really never crested. So I will say I have seen a bit of an uptick in more of the international arbitrations, but it's been a little cooler on the domestic side, but it's largely been consistent with what Susanna described.
Mm-hmm. Okay. And Kevin, I understand, I appreciate it's perhaps anecdotal just based on your own observations, but maybe a slight uptick. And COVID related, or was it because of issues that would have arisen regardless, just because there's a healthy economy? And
it's a fair question. I think the ones that I'm seeing have been more to do with some uncertainty in the commercial landscape, whether with governmental changes, the uncertainty about nationalization in certain countries, which different economic factors, more global drivers, and that can certainly be impacted by COVID and by what has been going on in the markets for the last 19, 20 months. It's hard to really peg it down to say that is specifically related to one issue or related to COVID. It isn't directly, they have not been directly COVID related, at least the matters I've been talking about with my colleagues.
And natural disasters or issues related to storms and the rest, that's been a source of some issue of disputes or not. I'll just sort of open that up generally. I think we heard previously when we were discussing
Winter Storm Uri definitely spun off some work. I don't know about the others, what the experiences were the others on the panel, but that is an example of one that definitely had some impact.
Mm-hmm.
Yeah, I would echo that. I think even more so than the pandemic, the winter storm was a work generator.
Okay. So again, interesting. Theresa, were you going to add something?
Yeah, I just wanted to jump in sort of on the conversation and, sort of echo what Ed had said. I think Jean, Susanna, and Kevin are all sort of similarly situated in terms of where they sit in the industry. I think we probably, or I probably see a little bit more of the types of disputes that Ed sees. And while we haven't seen the force majeure events that perhaps we were expecting at the start of the pandemic, I think the issues that have arisen have been interesting, because usually in a force majeure event, you have everybody sort of aligned as to whether it is or is not a force majeure event. And with the pandemic, I think you're seeing situations where in the complete supply chain, different people in the supply chain are taking different positions with regards to whether something is or is not force majeure. For that same reason, Ed also mentioned sort of the uptick in litigations in soft markets. I think we've been lucky in this that we haven't seen the uptick of big claims, but what we have seen is sort of an uptick in the smaller claims. And I think that marries nicely with, if you sort of look in the supply chain, who has been sort of the most impacted as a result of pandemic related issues.
Mm-hmm.
Yeah, and I think from a legal perspective, both Winter Storm Uri and the pandemic raised very interesting questions about force majeure, and most companies found themselves on both sides of the equation, right? Like issuing force majeure notices, but also receiving. And that raised interesting questions too, as to consistency, right? Like as Theresa was saying, sometimes when you receive a force majeure notice, say, wait a second, this is not force majeure, but then you are issuing one. And it was like, well, for me, that is force majeure, so very, very unique events. And they raise similar issues. I think that Storm Uri happened faster and disrupted more businesses and supply chains and all that than the pandemic. I think the pandemic, companies just activated their emergency response processes and were able to operationally take care of things better than Storm Uri, because Storm Uri was it was too quick, and it definitely disrupted a lot of contracts.
Okay. So again, when we think about disruption, generally people are talking just about, under the past year and a half, but it's a particularly important point, I think, for this group. And Theresa, just back to some of your observations, would you draw any distinction in terms of what you're experiencing, any difference, say, between litigation filings, either issues you're pursuing or defending against, and arbitration? In other words, are you seeing more of a shift in the mix of types of matters?
Yeah, I think for the most part, we're seeing more activity in the arbitration space. And I think because the arbitration space has adapted a little bit more easily to the pandemic than the courts have. I know in various jurisdictions, the courts are still closed and have been for the last year. So our cases there are moving very slowly. The cases that are being filed in the local courts, generally, I've seen a decrease in those, just because people are still sort of waiting for life to get a bit more back to normal. In the arbitration space, like I said, I think arbitrators, mediators, and parties have adapted very quickly to the virtual aspect, virtual hearings, virtual mediations, and that's sort of allowed business to continue as normal.
Yeah. And in many ways, that's the excellent lead into the next sort of broad topic we wanted to discuss, which is how disputes really are getting resolved. And, we're beyond the point talking about, can you do things virtually and what tools are available? Everybody knows that at this point. But thinking forward now, those involved in arbitrations, arbitrators, parties, lawyers, everybody's going to have a choice, institutions. And I've always said the technology that everybody's using, it's been around for a long time. We had the AAA-ICR, we had Zoom accounts 2 years ago. They weren't used that often. We had a lot of hearing space with great technology, but when it came right down to it, parties and arbitrators and lawyers, they generally wanted to conduct their arbitrations as they had in the past. And so the demand for technology really, frankly, it didn't match the capabilities that existed. The legal field is somewhat conservative, and this did force some change. And again, I think that in many respects, arbitration lived up to its promise, right? It's more flexible, easier to accommodate parties, and easier to adapt. But the question still is, now that we're moving into an environment where there's a choice, and people are experienced both with virtual proceedings and in-person proceedings, what is the preference? So you guys, all of you, generally, are the ones who are likely calling the shots on that. Of course, your outside counsel, we got them, they're going to weigh in, as will arbitrators, but you've all got probably the most important perspective and voice on that. And so the question is, what are your preferences going forward, where you can have an in-person proceeding or where you can conduct things virtually? What are your preferences, and what have you learned in the past year and a half? And Theresa, we can, if you will, start us off with that one.
Yeah, sure. So I'll start with sort of mediations, right? Prior to the pandemic, I was a big believer that mediations had to be in person, that if you held it virtually, it wasn't going to get anywhere. And I have become a total convert throughout the course of the pandemic. I think this taught us that virtual mediations can not only be extremely effective, but in some cases better than in-person mediations for a couple of reasons. Number one, I think you have reduced costs of counsel and parties and reps traveling around. Number two, I think you can mobilize a little bit quicker because it's easier to sort of get on somebody's calendar. If it's just going to be a Zoom call or a team meeting than it is if they have to make arrangements to be away from the office. And third, and I may be in the minority in this, but I frankly think that online mediations are draining. I would much prefer to be in a room for an extended period of time, and being on a Zoom or Teams call for 8 hours is absolutely draining. So for the mediators out there that say, oh, well, I like to get parties in a room and wear them down, just put me on a Zoom call for 8 hours and you will absolutely wear me down. For arbitrations, I would say the jury's still out. We've had a couple of very successful virtual hearings on dispositive issues that went very well. Again, those are just short 1.5 day, 2 day hearings, couple of witnesses. I think in that context, the virtual hearings work very well. I think for any period longer than a couple of days, though, for the reason that I just mentioned on the mediation, it does get wearing. It's very easy to sort of get distracted with email and other stuff that's going on the computer. So I think for those types of cases, the jury's still out for me.
Okay. Kevin?
I think Theresa raises a really good point in terms of the distraction side of things, which is why for evidentiary hearings, longer hearings, if we're being distracted, I'm also concerned the panel is getting distracted. So for the larger matters, for the longer hearings, I definitely still favor in person. I also think there's an increased ability to, I guess, react in real time if there is certain issues where you maybe need a visual, you need something to clarify initial in response to a question from the panel. In person, there's still probably a little bit more facility to do that. In terms of the opinions of the outside counsel, I don't know I'm curious what the rest of the panel has experienced, but you mentioned, the legal profession is conservative. Many of the partners handling our matters would much rather be in a room because that's what they've been doing for a few decades. So you have to sometimes push back if you don't think it fits with that hearing, or that, for procedural matters or other things like that. Obviously, that can be done by telephone in many regards, but I do think that the move to virtual is probably permanent, with case-by-case governor on that in terms of what is actually occurring on that day. And then on the mediations, I've had virtual ones that have been quite successful, and it probably is that reason I hadn't really connected those dots, that the people in the other room were tired of sitting on their screen. And actually saw some movement that maybe you don't see when they're sitting there getting a catered lunch and just answering their work emails and letting time pass. So I would echo those comments, and I think it is something that is probably, there's been an inflection point, and it is a change that will last.
Mm-hmm. Okay. Ed?
I've been extremely impressed with how fast both the courts and the alternative dispute forums have really adapted to kind of the virtual world of hearings and proceedings, and how the technology has kind of advanced, and it has caused us to think differently on a lot of different fronts, including the counsel we choose to deal with these cases now. Because certain counsel are probably a little more tech savvy than others. But I agree with Kevin. I think we're going to see some aspect of virtual hearings here for permanent purposes. I do think, though, that the preference is still to have in-person hearings in many of the big cases. And there's a lot of reasons for that, right? Just the comfort of real-time interaction, reading body language and what have you, and just the personal interaction that can be quite influential. So I think you'll see, and I know from the outside counsel that I've spoken with, most of their preferences to have in-person kind of proceedings, even on the smaller matters, right? I think that's largely due to they're just accustomed to doing that, and it's just kind of hard to change old habits. But I do think we're going to see a lot of the preliminary hearings handled virtually, and people are going to be more comfortable with those kind of things. Some of the low-level depositions you'll see to continue to be handled virtually. I was a skeptic going into this, particularly on the document management side, in managing the visuals that you're putting forth in a proceeding, and I was quite impressed with some of the outfits that are able to handle this for you if you don't have the capabilities of doing it yourself. That made the hearings go just as smooth as if you were in the courtroom or in arbitration itself. So it's a game changer in my view, and we'll see a lot of benefits coming out of it. But I do think that it's going to be one that's going to be selectively done, as opposed to whole cloth adopted for all cases.
Mm-hmm. Susanna?
Yes, I'm a big proponent of virtual mediations like Theresa. I was very skeptical going into it, the first time, like, oh, mediation, you need to be in a room together for sure. But no, it has been very effective, and I think even more effective in certain circumstances, because it's not like you're together and then you go into a separate room. It's just everything is so much easier. I actually had one last week that we were all like even in our houses, we're not even together, like the team together and then connecting virtually to the other team. So it just adds a lot of flexibility. The mediator, I think in the end of the day, depends on the mediator, how effective the mediator is, but it gives a lot of flexibility, reduces costs, and I think it's equally effective. So I'm a big proponent. In terms of arbitration hearings, I think arbitrations are a little different. I think for the very large cases, you'll probably still have in-person hearings, but I think for, medium-sized cases or smaller cases, procedure hearings, damages hearings, all of those I think can be done virtually. It significantly reduces costs, and it allows, for you to get to the arbitrator schedule quicker, because sometimes you only need 1 or 2 days. Nobody needs to travel for that, so that's a lot easier. Allows associates, to participate who would probably not even get to go because of the costs. So you can train your associates better by allowing them this opportunity to watch. I think in terms of advocacy, I think the outside lawyers need to work a little bit on their style, because advocacy is very different on screen. You cannot just be reading from the other screen the whole time. I think they need to adjust a little bit. It's much harder to pay attention for extended periods of time if you're on screen. So I think some work needs to be done on visuals and advocacy. But I think it will evolve with the demand, the need that it's out there. Things will get better. And I think there is also an opportunity for some hybrid approach as well, that, you can have the chair of the tribunal and maybe one lead lawyer per side and maybe one client representative, and that's it. And then the rest of the team can attend virtually. So I do think that those opportunities will come up, and it's good. It adds flexibility and reduce costs. So Why not?
Gene.
I have very little to add. I think everyone's kind of covered the waterfront there. My personal experience has been, I think virtual hearings can work for things like procedural hearings and where it's primarily legal argument. Not a big fan of it for merits hearings or for the taking of oral evidence and cross-examination. I think all of that still works much better in person. And frankly, one of the things that's so difficult about international arbitration is people practice this in lots of different places around the world. It's not like if you're a Texas lawyer here in Houston, you tend to run into people that you see down at the courthouse every single day. You develop relationships, you make contacts, and you can maybe work on issues in an informal manner in a way that isn't generally possible for people who are hailing from different jurisdictions to do big international arbitrations. If you take away the in-person hearing, then you take away one of those last opportunities you have to really interact directly with someone and develop those relationships and have those informal conversations and connections. So I would, cost savings are great and efficiency is wonderful, but I'm still a proponent of a more in-person connection. I think ultimately it gets you a better result. But yeah, as we said, these are just my private musings for novelty use only.
Yeah. Well, that's why we're discussing it. And so, not entirely uniform views there, but, some consensus that when it really gets down to merits hearings, larger cases, you're going to want to have something in person, and that there's value to that because of what you learn. But, certainly aspects of virtual proceedings will be here to stay. Just in terms of the AAICR's own experiences, domestically and internationally, I think that there's some consistency with what we've heard today in terms of the cases we're administering and the types of issues that parties are willing to arbitrate virtually versus those that they're just, they want to wait and they want to have an in-person hearing. The international arbitrations have been a little, slower. It's been more difficult to get parties together in person from other parts of the world. And so you do see, at least in the hearing context, not as many taking place in person as we see domestically, but that's changing really every day now, fortunately. I don't know that I need to clarify, but when I say the legal community is conservative, of course, I'm not talking about politically. I'm talking about just their willingness and desire really to change and accommodate technology and new ways of handling cases. But again, I would agree. It seems like in terms of the parties and arbitrators we're all working with, there's a real desire to make things work, and real progress has been made there. We also already have touched on mediation. But if we can just spend also a few minutes talking about where we are with mediation, given that you can do those virtually, and given we are in terms of different types of disputes arising, and your personal and to the extent you can, your company's respective views on that. Susanna, you had mentioned mediation is particularly in your mind, or an experience, I should say, well suited for a change and more virtual proceedings. And again, I'll say that has been our experience too. It's taken some by surprise, but there seems to be a real willingness to adopt virtual mediation proceedings, and people feel comfortable doing it. It's a little surprising because you always talk about mediation. One of the benefits is getting those disputing parties together in person to try to work with each other, maintain those relationships. And you would think that aspects of that might be just a little bit more difficult with virtual proceedings, but nonetheless, we're finding that parties are enthusiastic about going forward, and the experiences have been good. So, Susanna, you expressed your view that you think that's one area where you've seen some change. Has this, would you say that as developed more of an organizational view, or other lawyers in your department have the same thought? Has it led to the incorporation or a policy that you're going to include mediation clauses in more contracts, or is it really not at that point?
Well, our policy as to mediation is that we should always try, right? Before you try a case, before you have an arbitration hearing, you should always try to resolve it amicably, because at the end of the day, we want to explore and produce oil and gas. We don't want to be litigating disputes when we don't have to, right? So it has always been, and it's always helpful to spend a day with the other side and the mediator, learning about the strengths and weaknesses of each side. It's never a waste of time or money, because you always learn something, right? You learn more about the psychology of the dispute, which is hugely important in every dispute. So I think we have always been proponents of mediation in every single situation. As to the virtual, I think it's each person may differ, I think it's very personal, if people like to be on screen or not, or some people are more like face-to-face people. I think it depends. If you ask around, you get all sorts of answers. I just think that in terms of saving cost and time, and I think it's all about making the lives of our outside lawyers a little better too, right? So they are not always on the road and traveling, and if they can effectively do their work and help their clients without having to travel all the time, why not? And we reduce costs. If it leads to a resolution, I think it's favorable. So I'm a big proponent, but I don't think we are there yet to say that the organization now favors virtual mediations, because I think it's too soon to tell.
Okay. Theresa, thoughts?
Yeah, a couple of thoughts. I think corporate counsel have largely adopted this idea of virtual mediations more readily than perhaps some mediators and some outside counsel, for a couple of reasons. Number one, Susanna mentioned costs, but number two, also with the advent of the Green Pledge and some of the green initiatives that various companies are implementing, virtual mediations really do affect the carbon footprint in a positive way, right? There's less travel, there's less waste. I think where we've seen more of the pushback has not necessarily been with the other corporate party, but with counsel who are a bit more set in their ways that, oh, no, you have to get somebody in the room and you have to keep them there till 9 p.m. in order to get a good deal. I think same thing with mediators. I think some mediators who perhaps were used to just having parties come in and kind of learning about the case on the fly. In the virtual context, it's not as easy to do that. I think the mediators that have been truly successful in the virtual space and have actually been more ready adopters of the virtual space are those that spend a lot of time doing their pre-work, reading the papers, getting with the parties before the mediation. And I think that's a positive development, because that is the type of mediator that most parties want mediating their matter.
Kevin, I recall an observation from you earlier, an earlier call, maybe a slightly different view about mediation on the whole. But you can tell me if I'm recalling that correctly or not.
Yeah, I don't know if I would say slightly different. I think I am a proponent of mediation. I say to my business stakeholders, hear me say this a lot, that we're in the energy business, not the legal disputes business. Mm-hmm. So an exit ramp from the dispute that leads to a commercial resolution that is right for the business, I'm all for that. And the sooner the better. In fact, I think the numbers bear out. You save a lot more money exiting litigation at strategic times versus let's save some money by doing it virtually rather than paying for a couple of flights and hotel rooms. So I am in favor of it. It's really more of a case-by-case basis. I think sometimes a rush to mediation with the wrong, it's a little bit of alchemy. I mean, it's hard to really put your finger on the formula, but sometimes you just have a situation that is not right for early mediation. One side is pushing for it. You get in there, historically, you would have flown, rented a car, and you set up camp for a day, and the other side walks in and says, here's our demand. It's 50% higher than our best day would ever be in front of the tribunal or the court. And you're wondering why you are in, rural wherever, and how long it's going to take you to return the rental car, because this is a complete waste of everybody's time. I think the virtual mediation lowers some of the barrier for having preliminary talks, because you could have a mediation, identify a mediator, have it virtually. You don't have as many of the hassles and the expenses that lead up to that. And then if it goes nowhere that day, you can always reconvene at a later time, and there's probably a little less reticence from the sides to reconvene if you've already done it virtually, and there's the prospect of reconnecting virtually. So I don't want to give the wrong impression that I'm against mediation, but it's really, I sort of want to pressure test it. If we're going to go to a mediation, I want to make sure that both sides are actually interested in mediating. And it isn't just we have to check this box because our in-house counsel guidelines say we have to have a mediation right before we're allowed to take a matter to the merits hearing. So.
Okay, great. Gene?
I'm somewhat ambivalent about it. We don't have a policy one way or the other about mediation, at least in my group, or as far as I'm aware. I certainly may, and I may not know it, in which case I'll learn after. Sometimes mediation is fine, but I don't see it as an absolute necessity. Certainly engagement with the other side, business to business engagement, and having direct discussions about how you can settle a case tends to come up as a matter of course in any event, but I'm always a big proponent of that. Formal mediations, I haven't had a whole lot of success with them. Perhaps it's a me problem, but they haven't generally led to resolutions. But in the right case, I think I'm probably more in Kevin's camp. For the right case and the right mediator and the right circumstances, probably make a lot of sense.
Mm-hmm. And Ed, you mentioned earlier, you're talking about, when the market's soft, it can be a little bit tougher to get parties to settle. But I think that was more of an experiential observation. Any views about the process overall?
Well, litigation is always the last resort, right? So we're always looking for ways to resolve this amicably without going through litigation to do it. And mediation is one of those means for doing it. But I have had more success settling cases just through senior management kind of discussions. So we always include in our contracts a step that involves kind of senior management that's kind of unassociated with the project, not baked in on all of the claims that they've been dealing with, and can take a more business look at the resolution of the matter. Some contracts have mediation as a step in the process. After that, I prefer it as an option. a lot of times when you have mediation that early in the case, if it hasn't been settled at the commercial level, it's probably a little too early to settle at the beginning of the case before you initiate arbitration or litigation. My experience has been that, more cases I've had settled through the second round of mediation rather than the first. The first has been kind of a failed process, and then after the parties initiate some discovery, and we go a few rounds, and then people can assess the weaknesses and strengths of their case a little better. Based on that, then I think you have a higher degree of chances of having a successful mediation, because I've had mediation that failed in the first instance, and we had some discovery, and we get closer to having to actually litigate this thing, and we take another round at mediation, and it's settled. So in my view, it's a matter of preference, and even within our organization, there are those that are quite amenable to mediation, and others that take a more kind of wait and see kind of approach to it, as opposed to having a mandatory provision in the contract.
Mm-hmm. Ed, in your agreements where you have a requirement that members of the management team meet prior to commencing any formal sort of dispute resolution process, do you put time limits on that?
It has normal kind of time limits. You might have 30 days, 60 days.
Mm-hmm.
It's in the process. We don't want the efforts to get the matter resolved stalled by discussions, but the parties are free to continue those discussions as long as they want before you initiate litigation. But there's a time clock that we will set a time period that, after that time period, any party can initiate that next step in the dispute process, even if those discussions are ongoing and they're not bearing any fruit. But the parties are free, if they're having successful discussions, they're going to delay the next step in the process as those discussions continue.
Mm-hmm. Okay, helpful. Another question, and actually I'm seeing a few of these, perhaps the related issues, questions among those attending about arbitrator selection. And, for the types of cases all of you involved in, you're going to want people that are experienced. Some of the claim amounts you're dealing with are quite substantial. Subject matter expertise is important. Expertise, reputation, and experience serving as an arbitrator is important. What are your thoughts about the pool of arbitrators generally that you see and that you think about that you would choose from at the moment? Are there sufficient numbers? Is there additional development that's needed? Obviously, it goes without saying that diversity needs to be a continued focus. I'm assuming you would all agree with that. But Ed, again, I think you had some thoughts about this topic generally, and if you can share those, is the pool of arbitrators sufficient?
Yeah, look, there are great arbitrators out there, and we have a very good pool of arbitrators out there currently. My concern is I'm not seeing the next wave of arbitrators that are going to be handling cases in the future. We see the same names popping up, and everybody is seeking those arbitrators. But those arbitrators are aging out. And I'm not sure where the next wave is going to come from, where you have experienced arbitrators who have been handling mega type litigation cases that have built a reputation now that you can kind of get a sense of their capabilities. And I'm not sure how I mean that's been a challenging endeavor for the arbitration agencies, because a lot of it depends on the litigants to select those arbitrators. And if we're selecting the same arbitrators over and over again, that doesn't help the process. So I don't know what the answer is to that, but I do have concerns that the next wave is not that visible to me. And the last thing I want to do is start selecting arbitrators where I have very little information on kind of how their experience level, how they handle cases, and what have you. So, we've got to figure something out here, and some way to start bringing more arbitrators on to these cases so that they can start building the kind of reputation and experience and that would lend you to select them in future cases.
Mm-hmm. Gene, do you have any additional thoughts on this?
No, I don't have any solutions in my back pocket. The only thing I would mention is, look, the next generation will show up eventually, because none of us live forever. The usual suspects will move on. So something will happen. But I think that one of the larger challenges for younger arbitrators is that it is difficult to work at a firm and act as an arbitrator from a conflicts perspective. And one of the things that might help is if we as users of arbitration are a little more nuanced in our approach, so that we don't flip out the first time we see someone has a disclosure that they, once did a case 30 years ago with, the junior associate on the other side or something like that. I think we need to be a little more commonsensical when it comes to that kind of thing, and that will help allow those who can't necessarily afford to just be an arbitrator all the time to both carry on their practice and also act as an arbitrator. But apart from that, again, no answers in my back pocket.
Okay. Theresa, Kevin, Susanna, additional thoughts on that issue?
Arbitrators? Yeah. I mean, I'll make just one quick comment that's probably going to be unpopular, but that's okay. So look, I agree 100% with what Ed and Gene said, right? I think you see the sort of the same list of names that, comes up and up and up. And while that's great and those folks are wonderful, their bandwidth is limited. And we've seen in many cases where we appoint sort of the usual suspects and they just don't have time in the calendar to accommodate us. And so I think as corporate counsel, we have a duty to develop the next generation of arbitrators. And that means in some of the small to medium cases, we have to take a chance on some of the unknowns, right? Some of the folks out there that maybe we've heard good things about, but your outside counsel hasn't had experience with them in the case, or they're not as well known as some of the usual suspects. And I really, really think if we don't make an effort to try to push our outside counsel to consider those names, there's not going to be a change and not a push towards younger, hungrier folks who frankly can probably give those types of cases the attention they deserve.
Yeah, I could not agree more with Theresa. I think it's a metaphor change. You need to push everybody involved and make folks get out of their comfort zone. I think in-house lawyers need to be very clear with their outside lawyers that they expect every time they want a list of potential candidates, the list to be diverse right? Communicate that expectation in advance. And I think institutions have a huge role to play as well when they make appointments or when they send a list to the bodies, to be proposing more diverse candidates. And I've been monitoring the chat box here, and Deanna posted, all the institutions that are dedicated to promoting, more arbitrator and diverse women and diverse candidates for arbitrators. So the information is out there, and you need to let those folks get experience and appoint them to your smaller cases, medium-sized cases, and let them have a track record. And that's the only way. But I don't think, I disagree with Jean that you just let it happen. I mean, we have to be more intentional about this, and because that's the only way to make things happen.
Okay.
I'm conscious of time. I'll just be really quick. I agree 100% with Theresa and Susanna. I actually had this exact conversation about a month ago with my outside counsel when we were looking at some candidates, and they were complaining about, Shell is a signatory of they weren't complaining about Shell signing this. I'll get back to my point, but Shell's a signatory of the ERA pledge. And I said, where are the candidates of, diversity and gender and other on the list? And they said, well, we want somebody experienced, and there aren't enough experienced candidates. I said, well, how did they get experienced if we don't actually provide opportunities for that experience? And we ultimately found the right matters for somebody who's maybe doesn't have 20 years of arbitral decisions, but is obviously very bright and capable, and will let that person cut their teeth on a smaller matter. And it does take that deliberate action, I think, in order to develop that next wave and the more diverse wave of arbitrators.
And let me say one more thing, completely agree with Kevin. One more thing is that, sometimes the best arbitrator is the one that will dedicate time to your case, will study the file, will work hard. And someone who has experience in international arbitration that is willing to take the time to understand the matter and be influential with the other two arbitrators, that's all you need. Someone who is very well regarded but knows nothing about your case is no good. So just be open-minded too.
Ed, were you going to say something else? I was going to add, these are some really refreshing views. And again, I think that there's really consensus among the hope and need for both new experienced, acceptable arbitrators to be that parties can select from. I have heard, though, also a consistent theme over the years, just that ultimately in-house counsel's obligation is to their client, and in the end, they really need to look for and select the arbitrators that they believe are going to be best suited to resolve the case. It's not an excuse for selecting people maybe that are less experienced or diverse. But it just shows that, when comparing or weighing different considerations, that weighs heavier. And so I do really welcome these perspectives. Again, institutionally, there are large numbers of individuals that reach out, many with excellent backgrounds that want to be arbitrators. We have a roster of arbitrators, and the standards we have to add them can be stringent, but we have a significant focus on diversity. And in each sort of class of people that comes in, we have a very large representation each time. But ultimately, we do hope that we'll be able to increase the selection of some of these new arbitrators that, again, really have fantastic backgrounds. There have been a couple other questions that have come in. We've got about 10 minutes. And a few of them are related to this issue of arbitrators and selection. But a couple of them have focused more on the question regarding differences culturally among arbitrators. And perhaps, do you see differences? To what extent do you see differences in the culture of international arbitrators, perhaps from different parts of the world? I think is what the question is getting at. Any thoughts? I'll open that one to anybody who has a view. Theresa?
Yeah, so on arbitrators, I think sort of the biggest cultural difference we see, or that I see, is as that relates to discovery and document production. US arbitrators from the US are far more willing to give broad document production in cases than perhaps some of their colleagues from civil law jurisdictions. The other place that I've sort of noticed a difference between jurisdictions and how they approach the process is in mediation. I think just because of where the pool of mediators is in the US, it tends to be more of an evaluative approach. For example, if you think about the fact that in the US, a lot of mediators are retired judges, that's sort of used to what they're doing. I think in other jurisdictions, at least it's been my experience, it's a little bit more facilitative type of mediation. But those are just my impressions.
And any cultural differences with regard to, do you have any thoughts about any cultural differences, different parties from different parts of the world, or arbitrators with virtual proceedings? I think that might have been another part of a question. Are certain parts of the world adapting more or less?
Yeah, I think where the parties are situated in different locales, the virtual proceeding has been more readily adopted. If it's one of our business units in Houston and the counterparty is in Houston, there's a harder push to have it in person. But again, I think that's just a function of what is easier for the parties at the time.
I think with the time zone differences too, I've had arbitration hearings that we had to split in, like something that would normally happen in a day was split in 3 days just to accommodate all the different time zones. And on occasion I'm up at 2 a.m, but that's okay. That's international arbitration, I guess, but at least I didn't have to fly somewhere else and spend the whole week, abroad. So that's helpful too.
I see a cultural difference on a lot of different fronts, and as Theresa pointed out, on the discovery side, you see a whole different view between U.S. kind of centered arbitration and European centered arbitrations, right? But also, in the way of experts and how they treat experts. And even in contract interpretation, where you have some jurisdictions, your arbitrators, the pool of arbitrators are more strict constructionists than others. The same holds true with kind of equitable considerations, right? So, it varies around the world, and you have to be very conscientious of that when selecting those arbitrators. Because it can bear on the case and the outcome. So and just their personal experiences, right? I think what for example what we're seeing with COVID, I think it's a little unusual in the sense that COVID has been an experience that has impacted everyone's daily life. And so arbitrators looking at cases involving kind of COVID impacts are viewing that from the lens now of having personally experienced some of these kind of disruptions themselves. So it's not kind of the outside looking in at a case and never having worked a project or experienced kind of what the parties are arguing over. So it brings a different perspective to that case when you're arguing that you've been impacted, or if you're defending against an impact that's COVID related. So I do think you have cultural differences that crosses a lot of levels, and it's one that you have to be sensitive to when handling these cases.
Mm-hmm. Another related question: would any of you, or have you selected non-attorney industry experts? Obviously, we see that a bit in construction more specifically, but is that something you find on your list of qualifications? To lawyers, perhaps service to the arbitrators, and then somebody with some real expertise as an engineer or otherwise, perhaps. Do you ever see that in your cases? Is this something you desire?
Yeah, absolutely. I've used non-lawyer arbitrators, for particular cases, where there's a particular angle, be it engineering or accounting or something along those lines. It worked out very well. And there's a community of people who both have experience in their various disciplines and as an arbitrator.
And Gene, do you find when you want that it's something the other party or parties agree to, or is it something that becomes an issue and dispute?
It really depends on the case. Sometimes you see it where if it's a tripartite panel, if one party uses as a party appointed arbitrator, let's say someone who's a CPA, you'll see the other party do the same. There's sort of an equality of arms issue, and you might see someone with a legal background chairing, and things of that nature. But if you're talking about just sitting down and arriving at an agreed sole arbitrator, I can't recall an instance in which I've seen that happen. It certainly would be possible. And again, for the right case, I think it would make sense if the parties were to think in those terms.
Right.
I think you see it more in the kind of dispute review board kind of space. Expert determinators where you have some interim process to resolve technical issues on a project. I see it less in your kind of traditional arbitration, because typically while the issues may be technical in nature, it really tracks back to a legal question of whether there's entitlement under the terms of the contract or at law. So you don't see a lot of consideration given to non-lawyers in the arbitration panel, but we use a lot of non-lawyers in these interim processes that are just as important, right? Because if you've got a project that's being stalled by a technical issue because one party is saying that they're not responsible for it than the other, and you can't move on because it's hanging up a project time-wise. Those interim kind of decisions are very important to resolving the issue and avoiding a larger dispute down the road. Because typically when those get resolved on an interim basis, unless there's some compelling issues that come up in the end, those decisions are held up and people move on, right? Because the matter's resolved and the project has gotten on to new things. But I don't see a lot of it in the arbitration space because of the legal issues that are tied to these disputes.
All right. Well, I've tried to get to a number of these questions. There are quite a number that have come in, but our time is up. And I appreciate all of your insight and energy and commitment to the process. And I really appreciate you for joining us this morning. And with that, I think our program will end, unless I hear from Steve or others. I think we just wrap it up. And again, we thank you all for participating this morning. Enjoy the rest of arbitration. Bye-bye.
Thank you.
Thank
Thanks,
you.
everyone.
Bye.